I just wanted to do a very simple diagram of how a company works. Obviously, a company it's a legal entity, so it can enter into contracts on its own behalf, but it's an artificial person, it can't think for itself. And so the company appoints a board of directors who will take decisions on its behalf. The company is, however, owned by the shareholders, and so ultimately the board of directors are accountable to the shareholders. Now, depending on how big the company is, you might have 2 or 3 people who hold all of the shares, which makes the process of holding the board of directors much simpler, because you just have to persuade 2 or 3 people to engage with the company, and the board may often report directly to them. However, where you've got very big publicly listed companies, you may have thousands of shareholders, some of which may have a very small shareholding in the business, some of which may have a very large shareholding. But when you've got thousands of shareholders, it becomes a lot more difficult to coordinate the shareholders to hold the directors accountable. Now, if you go to the directors, however, and say, Mr. Director, we'd quite like you to take this into consideration when you're running this company, or why aren't you thinking about this? Then the response from directors will nearly always be, well, we are under pressure from the shareholders to produce profit, so we can declare dividends, which will keep our shareholders happy. If you go to the shareholders and say, well, shareholders, why aren't you controlling the board of directors? You've got that situation where you may have thousands of shareholders and no one shareholder has enough clout to change anything. And you may have a lot of different shareholders with a lot of different views about what should be going on in the company. So you have this kind of disconnect between the board of directors saying, well, really we need to focus on profit, and the shareholders not doing anything to change that view. But if we zoom out a little bit, there are a few other people in the background that we can start to think about if we want to try and start influencing the behaviour of the company. So the board of directors owe various duties to the company, which I'll come on to shortly. But because they owe those duties personally, they go out into the market to buy insurance in the event that they end up getting sued by the company or shareholders or the general public for a breach of their duties. So they will go out and buy what's known as directors and officers insurance. Now, it's obviously in the interests of those insurers that the board behave themselves and comply with the law, because in the event that the board don't, then there's a risk of claims, and ultimately the insurers will end up picking up the tab for those claims. So one way that we can try and get the board to behave is to go to their D&O insurers and perhaps say, well, have you thought about this risk? This company is doing this. That's potentially in breach of the director's duties. Can you exercise some influence over the board to try and get them to change their behaviour? And then if we look down on the other side of the screen, there are separated out some different kinds of shareholders. Now, starting at the bottom, we've got private investors. So these are sort of the mums and dads, or you and I, people who just may hold a few shares in a company. You might hold them in an ISA, or you might just decide you might have inherited them, or you might just decide to go out and buy some shares. And so we have these people who may have very small shareholding, who are very unlikely to get involved in the running of the company, purely because they haven't got the time, they haven't got the expertise, and their shareholding is very small. If we go up a step, we've got charities and universities, for example, where they may receive an endowment and they have to make that profitable, so they can use the profits for the purpose of the charity or to run the university. And so those sorts of investors hold much bigger shareholding, and may also have to think carefully about where they invest their money, because they might be subject to certain charitable purposes and that sort of thing. And then next step up, we've got pension funds. Pension funds hold an enormous amount of shares, and they are the sector that is probably the most likely to be able to organise themselves to influence company behaviour. Kind of moving up to the regulators here, pension funds, D&O insurers and directors are all then regulated by regulators. And so the idea is that the regulators are out there keeping an eye on what all these different actors are doing to make sure everyone's playing their part, and ultimately that should control the behaviour of the company. So what tools do we have available as an NGO to try and influence company behaviour? There's lots of different tools out there, many of which will be familiar to you. There's media and publicity, so simply running campaigns. Divestment, which is where you encourage people to sell their shares in a particular company on ethical grounds, because you disagree that they're manufacturing weapons, or that they're selling tobacco, or are contributing to climate change. You can have pressure from insurers, which I was just talking about. You can try and go to the D&O insurers and try and get them to change corporate behaviour. You can try and change the law, which is obviously what a lot of NGOs focus on, try and improve the law and get better laws passed so that companies have to comply with those laws. Shareholder resolutions are another way of doing it. If you can mobilise the shareholders, particularly if you use pension funds and that kind of thing, who own large shares in these companies, you can ask them to bring a shareholder resolution calling on the company to change the way it's acting. Stewardship is very similar to shareholder resolutions. It's encouraging active shareholder activism. It's encouraging the shareholders to get involved in the running of the company. And then the two in the middle, which are really the focus of my talk, is litigation to enforce legal obligations and complaints to regulators. So I'm just going to talk about those two in a little bit more detail. So whether you're going to a regulator or the courts, the arguments are often going to be very similar. And the main areas that I'm focusing on in my work is firstly company reporting. So since last year, companies in the UK are now required there's mandatory carbon reporting rules. So companies in the UK are required to disclose their carbon emissions in their directors' reports. We also have strategic reports in which the directors have to report on the principal risks and uncertainties facing the company and on environmental matters. This came in October last year, and we're seeing the first kind of raft of these reports coming out now. And if you are interested, Shell's report has been published and BP's report has been published, and you'll see how in those reports they go through various risks, and including to some extent climate risks. Whether they've gone into climate risk sufficiently is a different question, but you can see they're starting to report on these things. If those reports are found to be inadequate, then we can make a complaint to a regulator, or if you can mobilise the shareholders, you can bring a shareholder resolution to try and change the report. And either of those routes could end up in court. The regulators can ask the court to order the company to change its report, or the shareholders might decide to go to court to ask the court ask the court to order the directors to change the report. If the court agrees that the report is defective and orders the company to change the report, then the court now has the power to make directors personally liable for the costs of those legal proceedings, and also for any loss that's been suffered by the company as a result of the errors in the report. It is also a criminal offence in certain circumstances if you can show that directors knew that they were reporting inaccurate information in the report. So this is quite a powerful tool, and so one thing we can do as an NGO is go through these strategic reports that are now appearing and analyse them and try to figure out whether what they're saying is sufficient, whether the business case stacks up, and if it doesn't, then make a complaint to the regulator or try and mobilise the shareholders to do something about it. We've just seen, I don't know if people have been following it in the news, but a shareholder resolution was brought very recently by Exxon's shareholders. Now, Exxon is listed on the US equities market, so it wasn't done under UK company law, it was done under US law. But the shareholder resolution was brought, and Exxon agreed to issue a report setting out the effects of climate change on its business. And that report came out last week and has been commented on quite a lot in the media because it's quite staggering what they've reported. I don't have very much time, so I'm not going to go into it now, but if anyone's interested, then you might want to have a look at the report that Exxon published last week. And then we've got directors' duties. The most important one here is that directors have duty to promote the success of the company. And since the Companies Act was introduced in 2006, this includes, this requires them to have regard to consequences in the long term, which is an important change, and also the impact of the company's operations on the community and the environment. So again, the idea here would be to mobilise the shareholders to challenge, for example, a company's decision to allocate capital expenditure to, say, a tar sands project that's going to be of marginal profitability but have an enormous impact on the environment. And the argument would be that in doing that, the directors have failed to give adequate consideration to long-term consequences of the decision and the impact on the environment. Yes, I'm just going to move on to this one, sorry. So then, duties of pension trustees, that was just the other aspect of the diagram down in the left-hand corner. Trustees have duties as well to exercise their powers of investment in particular ways. So instead of going straight after the directors, what you might want to do is go after the pension fund trustees to try and get them to compel the directors to behave in a different manner. And so the sort of duties we're looking at here are a duty to exercise their powers for the purpose it was intended, duty of adequate deliberation, duty to exercise reasonable care and skill. So the argument here would be that if pension trustees are not giving any consideration to climate risk in deciding how they're going to run the pension fund, then you could say they're negligent or that they're failing to give adequate deliberation. There's lots of ways that you might construct the argument. So then just to come on to the question that was posed as part of this panel discussion, are corporations, the anatomy of a corporation, is it built to kill? I don't think it is. However, that is subject to three things. First, directors need to respect their legal duties. Secondly, you need shareholders who are willing to engage with the company to act as a proper check on the directors and to ensure that the directors don't just focus solely on profit. And thirdly, you need the regulators and courts to be willing to step in and be bold when you need them to be, and particularly regulators, because court action can be very expensive, and so if the regulators have got teeth, then that could be a very good check on the actions of the company. Okay, thanks.
Speaker's doing an excellent job of keeping to time. Thanks tremendously, Elspeth. A well-informed, helpful exposition of the disconnect, I thought, between company boards and shareholders, possibility of litigation, and an upbeat conclusion with some provisos. I'm sure some questions will be dished on that. The third speaker in the panel is Carrie Bradshaw, who's done a lot of work in this area and pursuing some of the themes. She's working on a book entitled Corporations' Responsibility of the Environment. I think that about says it all, doesn't it? Thanks very much.
Speak into the microphone. Okay. I just want to thank the organisers for inviting me to be here today. I'm genuinely flattered to be part of this morning's panel as well as the other speakers here. The rest of the day. I also want to congratulate the organisers on a fantastic conference. I think you've done a really good job, and the lineup looks brilliant. The conference organisers asked me to talk a little bit about the anatomy of the corporation, the DNA of the corporation, and to think about whether it's built to kill and what this means for the role of corporations within the environmental crisis. And when I was thinking about the DNA of the corporation, what came to mind immediately was the work of Joel Barkan. And Joel Barkan provocatively describes the corporation as a psychopath, pathologically pursuing profit and its own self-interest, with no regard whatsoever for the harm caused to others. And on this view, corporations really are part of the problem and are very unlikely to be part of the solution. John Barkin doesn't really think much of corporate social responsibility. For him, it's somewhat oxymoronic. My view is different. Corporations indeed are part of the problem, but I think they are also part of the solution. There are real limits to what governments can achieve alone, especially across transboundary borders. And at the same time, whilst we know they do a lot of bad things, corporations are hubs of enormous expertise and influence. And their influence, I think, is something that we've been mistaken to ignore. But to operationalise their role, their problem-solving role, corporations need to be moved away from that idea of a corporation as a psychopath towards something more akin to behaviour, which exhibits the existence of an environmental conscience. What is an environmental conscience? For starters, it's the very antithesis of corporate psychopathy. When we talk of conscience, we are talking of a commitment to values in addition to profit. Behaviour which evidences some type of pro-social, unselfish, other-regarding nature. Evidencing concern for someone or something beyond one's own material interests. So for an environmental conscience, we're talking about concern, obviously, for the environment. Now, I'm sure many of you here today would be sceptical about the existence of strength and environmental conscience, especially within corporations. And you'd be right, I think, to be sceptical. But I also think this means that we should discount the possibilities. Not only are there numerous strands of research which provide us with at least glimpses of the existence of environmental conscience, but there's also quite a lot of evidence to suggest the existence of some type of environmental mindset within a company correlates with significantly improved environmental performance. The problem, of course, is that corporate behaviour more generally tends towards psychopathy more so than it does to environmental conscience. There are exceptions to that, obviously, but generally speaking, I think that's what most people think. And the reasons for this are remarkably complex and interrelated. And I'm going to talk just about two of what I think are the biggest reasons, the biggest causes of why corporations are more likely to behave as a psychopath. And the first is the shareholder-centric model of the company, which Elspeth has already alluded to, and Tim has also indeed. So firstly, the shareholder-centric model of the company, and second, the effect of organisational norms on individuals' own sense of reality within a group, within a corporation. And as I'll explain, what I think is the very weak duty to the environment in section 172 of the Companies Act, which Elspeth introduced us to, I think would be largely inadequate in closing that gap between corporate psychopathy and environmental conscience. So before talking about those two causes or drivers of environmental responsibility, I'll just point you very briefly to the research that gives us glimpses of conscience, of environmental conscience. First, there are a number of laboratory-based behavioural experiments, essentially gaming scenarios which are some sort of take on the prisoner's dilemma. And these experiments demonstrate beyond reasonable dispute that the vast majority of human beings are pro-social or other-regarding, and that in the right circumstances, most can be counted on to make personal sacrifices, albeit modest, to behave with conscience and avoid visiting harm upon others, including visiting harm upon the environment. The results are remarkably robust. And now, if you're sceptical, please just come along with me for now and look at the research later. Secondly, and to complement this body of research, there's plenty of evidence from the environmental compliance literature which exists to challenge that assumed amoral, conscienceless behaviour that we assume about corporate actors, including a commitment to the environment at the top levels of corporations. In particular, this body of research routinely throws up normative or internalised commitments to environmental protection or environmental responsibility. Now, explanations of that sort of behaviour are deeply complex. We can't generalise across the board about the existence of those commitments, but their existence is significant, particularly when we square that with Joel Barkin's characterisation of the corporate form itself as a psychopath. Again, you might be sceptical. Please just come along with me for now and look at that research data itself. Because what I think is more important is not the existence of this environmental conscience, but understanding what happens to it when people get into a corporation and start making decisions in groups. What happens to these glimpses of conscience? How do we get from conscience to the corporate psychopath? This is in part due to the basic structure of the company, or the Anglo-American corporation, limited by shares. And Elspeth's already done a lot of the work that I plan to do here, so I can cut out a big chunk of my presentation, which is lucky for you. As we know, the company is a legal person. It's distinct from its shareholders. But whilst it has separate legal personality, the corporation is nonetheless shareholder-centric. And I want to dispel some myths before I go any further. This doesn't mean that shareholders run the company or make day-to-day decisions, as I said, they don't. It doesn't mean that shareholders own the company, they don't. It doesn't mean that directors owe duties to shareholders, they don't. The company owns the company and its assets, it's directors who run the company on a day-to-day basis, and they owe their duties to the company, not to shareholders. What the shareholder-centric model of the company implies is two things. First, it implies that the goal or purpose of the corporation is defined by reference to shareholders alone, to the exclusion of other stakeholders, including companies, employees, and other more nebulous stakeholders such as the environment. So the company is run in the interest of shareholders, not other broader stakeholders. And we see this, as Elspeth said, in section 172 of the Companies Act, which states that a director must act in a way which promotes the success of the company for the benefit of its shareholders alone. Second idea that a shareholder-centric model of the company implies is that shareholders hold a number of quasi-participatory or voice rights in the company, again, to the exclusion of other potential corporate stakeholders. And these quasi-participatory rights include the right to vote in the AGM, the power to appoint and dismiss the board of directors, as well as the right to enforce directors' duties on behalf of the company. So, shareholder exclusivity as a corporate voice and corporate goal orients decision-making to the interests of shareholders. And this tends to lead, not because of company law, but because of a number of other market factors, this tends to lead to a focus on short-term profit gains. And this focus on short-term profit gains, often measured by share price, it has obvious negative consequences from an environmental perspective if corporations have to sacrifice short-term profit in order to protect the environment. And I think at least in this audience, I probably don't have to argue too much that that is the case, although in company environments they often do have to argue the otherwise, the alternative. Shareholders also benefit from limited liability. And what this means is that other than a few very narrow circumstances, shareholders cannot be called upon to meet the liabilities of the company. Now, the link between limited liability and all sorts of incidents of environmental irresponsibility is well documented. Limited liability creates a classic moral hazard problem where the ultimate beneficiaries of corporate wealth don't bear the costs, at least indirectly, of environmental degradation or other forms of externalised damage, but they do reap the benefits. And in particular, and this is really what Tim was talking about with Bhopal, the limited liability of holding companies, a company which holds most or all of the shares in a subsidiary, means that corporate companies can and do legitimately structure their organisation so as to limit liability for all sorts of behaviour. So this was a big challenge in holding people to account for both part and holding the company to account. So the basic model of the company, one which is shareholder-centric, limited by shares, is in essence an organisational form that's not only insensitive to the concerns of environmental protection, but it actually creates a number of positive incentives for environmental irresponsibility. And it's for this reason that Joel Barkin uses that powerful language of the corporation as a psychopath, pathologically pursuing profit and its own interest with no regard to harm caused to others. Now, I would take issue with some of Joel Barkin's expositions on company law, and I won't get into those today, but roughly speaking, this model of psychopathy and the reasons for it that Joel Barkin explains are mapped in UK company law. And this is the case even with the existence of Section 172 of the Companies Act. So Section 172, as we know, requires directors to promote the success of the company for the benefit of its shareholders as a whole, but in doing so, have regard to the impact of the company's operations on the environment. But what does all this mean for that idea of environmental conscience that I mentioned at the beginning? Well, in reality, even with Section 172 and that duty to have regard, I think there's very little room for conscience within companies. Section 172, at least in form, does not permit profit-sacrificing behaviour for environmental reasons. Having regard for the environment must serve the interests of shareholders. It requires what I've called a business case approach to corporate environmental responsibility. As long as the interests of the company and the interests of the environment walk hand in hand, then great. As soon as those interests divide or no longer walk hand in hand, then it's the shareholder interest that takes precedent. So we might at best suggest that Section 172 is sort of a financially contingent form of conscience, but because it's financially contingent, it is necessarily weak. And it's weak because there are routine and often deeply embedded points of conflict between corporations and the interests of corporations and the environment. And Bhopal is a good example of this, but they need not be so extreme. Any business model which is premised upon consumption is very likely to be environmentally damaging, given the well-known link between patterns of consumption and environmental degradation. So company law, Section 172, that duty to have regard to the environment, pushes behaviour towards Joel Barkin's idea of corporate psychopathy. But as I suggested at the beginning, company law is just one of the factors that creates this incentive structure. And it's only one of the reasons or one of the causes of environmental irresponsibility. And I think equally important is the fact that organisational life constrains people's own sense of morality or conscience, environmental conscience included. And these factors in an organisation have a tendency to make people behave like corporations, to behave like psychopaths, even though we have quite strong evidence to suggest 99% of people actually aren't psychopaths. So certainly company law doesn't help, but any form of group decision making is well documented as causing people to behave in ways which they would think unthinkable were they acting or making decisions individually or outside of the group scenario. And the managers not reporting toxic results in Bhopal is a good example of that. If we look at the board of directors who make decisions as a group, we have, again, a number of psychological phenomena which turn individual responsibility into group responsibility, and that in turn creates the conditions for environmental irresponsibility. So these psychological phenomena include risk shift, groupthink, and labelling paradox. And these involve taking riskier decisions because it's on behalf of an organisation, or acting in accordance with organisational norms despite inconsistency with one's own sense of conscience or morality, And then finally, the Abling paradox, agreeing to group decisions against one's better judgment in order to avoid conflict. And again, like the idea of a conscience, these types of group decision makings are well documented and pretty robust. So despite quite strong evidence which provides at least some hope for the ideas of kind of environmental movement within companies, the structure of the company and a number of organisational factors serve to mute that glimmer of hope that we have in environmental conscience. What does this mean for environmental lawyers? How many? 2 minutes. What does this mean for environmental lawyers, for CSR, for the role of corporations in the environmental crisis? Well, thinking about the structure of the company, which lends itself to psychology, I think is an obvious port of call. Environmentally minded reforms to company law. And the most obvious form here would be to implement a stakeholder rather than a shareholder model of the company, or to design certain inroads to limited liability in the case of environmental harm. So again, as Tim was mentioning, more opportunities for piercing the corporate veil. And indeed, calls have been made repeatedly for this, but they have been resoundingly unsuccessful. So, thinking about Elspeth's diagram of law reform options, if we're looking just at the idea of changes to law reform, I think reformers, NGOs included, need to be pragmatic. Alteration to that basic shareholder-centric model of the company is, at best, highly unlikely. There's also a pervasive orthodoxy which regards company law as a species of private, non-regulatory law, the corollary of which is that environmental concerns often aren't even seen as relevant to company law and the purposes of company law. So whilst I think it's important that environmental lawyers think carefully about ways in which we might get company law to be more environmentally friendly, we have an uphill battle even getting that type of reform on the agenda. Which brings us back to section 172 of the Companies Act. Even though the duty here is quite weak, having some reference to the environment within directors' duties is not insignificant. And while it's not the type of regulatory intervention which has any hope, I think, at least on the face of it, as closing the gap between psychopathy and conscience, it does, I think, provide a hook for further reform. And I'll stop now, but what I would question is whether certain types of more robust environmental procedures that we're familiar with in terms of environmental impact assessment or environmental management systems might be a better way in which to, on the one part, give environmental conscience room to breathe, but work within that dominant shareholder-centric paradigm, which, as I suggested, is going to be very difficult to displace. I think I'll leave it there. Thank you very much.
Thanks very much, Carrie, for another excellent presentation. Our three speakers have got this conference off to an excellent start. They've, between them, I think, ranged over all the possible ethical dimensions, from amoral to immoral, from ideas of companies having conscience to them being downright evil. All the possibilities have been touched upon. There's lots of scope for questions, but about 1.5 minutes by my watch to cram them into. There's a guy with a microphone somewhere about. Joe, are you around? Joe. If you have a question, please ask it, and if you could say who you are or where you're from and who the question is directed towards, please do so. I was half serious. There is time for a couple of questions. Richard is there. If you could place the microphone in front of this gentleman.
Thanks. Richard McCrory, UCL. I really want to just pursue this section 172 and whether you either kind of dismiss it as hopelessly qualified and it's really pointless, or whether there's more to it. Because I think, Carrie, the actual duty talks about a duty to the success of the company, and you just rather kind of equated it very quickly with that's the financial viability of almost the long-term shareholder. Now, I don't know, I'm not a company law specialist, I don't know whether there's been any litigation on that, but do you think you could argue that actually it's deliberately used the word success of the company? It doesn't say the financial viability is the first thing, and then you have possible granting environment. And actually the success of a company could include things like its long-term viability, its adaptability, its trust, which obviously all eventually have a shareholder some value, but it's actually quite a carefully crafted word, success, which you could actually pursue and persuade a court that does mean something wider. And my second question is, do you think you can have an environmental conscience just driven by self-interest, which is a slightly...
There might be questions for other speakers as well.
Yeah, so, I mean, I agree with you that the fact that we have this success of the company, in addition to the shareholders as a whole, is a potential avenue into divorcing the interests of the company from the interests of the shareholders. Elspeth might do differently here, but generally my understanding is that the interpretation has been to conflate the two, particularly because that was basically what the case law prior to the 2006 Act did. And in theory, director's duty is supposed to codify existing law. Now, there's debate about whether they do that. I agree that, and again, I didn't mention it because Elspeth already pointed us to that, was that there is a duty to think about the interest of the long term. What I did say was that this focus on short-term financial success is less about company law and more about a number of other factors that lead to a kind of rhetorical overlay to company law, which equates with shareholder wealth maximisation. Does that, yeah? The second point about an environmental conscience, I think it's there, but as I said, you have to have the right circumstances, and it's what are the right circumstances. And my idea about padding out procedures within a company is obviously against the backdrop of an existing and extensive form of environmental law and regulation. The idea would be that something within company law would complement, more so than existing company law does, those existing external regulatory frameworks. But I'm sceptical about conscience, and I suspect it probably is as well.
Yes, I think looking at forms of director's duty of care through the prism of something like Bhopal inevitably makes you sceptical. I can refer to one example I know of in the aftermath of Bhopal, where US chemical corporations were forced to adopt a new program of approach towards environmental issues and towards communities living around their factories. And it was an elective mechanism that they identified called their term responsible care. I've been through the minutes of the Chemical Manufacturers Association meeting where they decided to adopt the responsible care type of CSR program, and it was essentially pushed on the membership by the CEOs of Union Carbide and Dow, who were overtly concerned about the hailstorm of regulation that had hit them in the aftermath of Bhopal. And they described this particular CSR program as a chance to get in under an umbrella to fend off the regulation. So, although responsible care has now been established for several decades and undoubtedly is having positive impacts in various areas, at the outset it was a very pragmatic approach to fending off statutory regulation and maintaining an elective approach towards these kinds of problems.
In relation to the first question about how to interpret the idea of success, I think it's interesting to draw a comparison with trustees, and there is a debate in the realm of the duties owed by trustees. There is a case called Cohen and Scargill, in which it was said that trustees first and foremost have a duty to act in the interests of the beneficiary, and then that has kind of promoted a debate where people say, well, what does the best interests of the beneficiary mean? Does it mean the financial interests, or can you take into account things like, for example, the people who these whose pension this is will need a safe world to live in, as well as a pension to survive on. And the view that has been taken, actually the Law Commission has looked at this question, or is looking at it at the moment, and is publishing a report in July, but its interim report's already on the website, so anyone wants to look at it. And they have said, well, actually, we think that all that case was saying is that the trustees have a duty to exercise their powers for the purpose that they were intended, and that normally in the circumstances of a pension or just a general fund where the idea is to generate profit, the best interests of the beneficiaries means the financial interests of the beneficiaries. And I think probably the same applies in relation to the Companies Act. However, the Law Commission has been keen to stress, because I think that there are people who go to pension trustees and say, and try to encourage them to divest in fossil fuels and that kind of thing. And the response that they often get is, well, our fiduciary duties don't allow us to divest because we have to promote the financial interests of the fund. And right now, the financial interest of the fund says it's a good thing to invest in fossil fuel companies. But the Law Commission has been at pains to stress that actually, where you're talking about environmental and social responsibility matters, actually that is often in the financial interests, because a fund that is not taking those sorts of things into account is likely to perform worse. A company that's not taking those things into account is likely to be less well organised, is likely to be less productive in the long term. And so you end up, Carrie used the phrase, the business case for environmental responsibility. So you kind of need to make the business case, but actually the business case can be fairly easily made, and you don't always need to say, well, actually, yes, there is going to be a direct financial return for taking that approach, but more that actually, generally, a company that is taking these things into account is likely to perform better with the long term.
One quick question for T-Bic. There's a lady there in red.
Hello, my name is Priska Metz, and I'm from a citizens initiative called Ecocide in Europe. So we want environmental destruction recognized as a crime. And now we are also asking for an international court of the environment. And I would like to ask Tim, I think, yes, about the Bhopal case. Do you think if there was some kind of international court, would it have helped to achieve accountability for these corporations?
Yeah, well, optimistically, I'd say categorically yes, because I think that the chief problem that the Bhopal groups have faced in attempting to gain any kind of favourable decision in the US courts is a sort of innate conservatism, particularly, given that these are US industrial interests, both at home and abroad, that are going to be directly impacted by any precedent established by a favour that rules positively in favour of the Bhopal groups. So I think the situation requires the notional independence of a totally distinct jurisdiction from India and the US, and an international court dealing with environmental issues would be theoretically the perfect forum for that. Yes.
I noticed there were various hands going up, but I do want to finish this session. But if these guys have said something you didn't agree with, I think you should be buttonholing them and coming and ask them about them during the coffee break. But thanks very much to you three for getting such good. See you in 10 minutes or so.
curso con algún amigo mío. Ahora mismo. Claro, lo que me preocupaba, más allá del ambiente acá, o sea, esto me está publicando, que tú ahora en la última revista constitucional de Oxford, la disputa con Carrie.
I'm like screwing myself over.
Hello.